15 years ago, when Ken Marcus founded the Brandeis Center, if he had put that idea into an AI platform, would it have come up with the concept of a nonprofit dedicated to advancing the civil and human rights of Jewish students, often through complex resource, intensive legal work, powered by lawyers and advocates, motivated by a mission and purpose? Probably not. Because when Ken saw was not just a theoretical issue, but a gap in how civil rights law was being applied and enforced when it came to incidents of intolerance and discrimination against Jewish students and communities. He understood the complexity of the legal landscape across Title VI, Title VII, Title IX, First Amendment, and beyond, and the need to apply those frameworks carefully and effectively to address anti-Semitism, particularly in the campus environments. He understood the nuances, how to distinguish protected speech from unlawful discrimination, and how to ensure the civil rights protections are not just theoretical, but actually enforced in practice. And he had that vision, the intelligence, the tenacity, and the humanity to build an organization to do exactly that. What began as a small operation has grown into a national organization with a team of almost 50 employees, multiple offices, and a wide network of supporters and partners. The Brandeis Center has helped shape the legal and policy conversation, clarifying how civil rights law applies to anti-Semitism, and working to ensure that those protections are real and enforceable for students and communities. That impact is not accidental. It is the direct result of Ken's leadership. It is my honor and privilege to introduce the person responsible for building and leading this work, Kenneth Marcus, the founder and chairman and CEO of the Brandeis Center.
Good morning. Thank you, Karen. Thank you all. Rabbi, I appreciate the remarks. Good to see all of you. Just weeks ago, here at Harvard University, the Harvard College Debating Union proposed a topic for its World Schools Invitational: the Enlightenment era effort by European states to grant Jewish people civil rights in exchange for political assimilation, close quote. In other words, Jewish equality, yay or nay. The reaction was immediate, intense, and divided. Some defended the topic as a legitimate historical inquiry. Others recognized the premise for what it was, a provocation that would unavoidably elicit anti-Semitic responses. The topic was quickly withdrawn. At one level, this might seem like a simple misjudgment, an academic exercise that crossed a line and was corrected. But the speed of the backlash and the need to withdraw the question altogether points to something deeper. Not just sensitivity, but uncertainty about what is open for debate, what is not, and where the boundary lies. To understand why this question struck a nerve, we need to be clear about what Jewish emancipation means. In the modern Western context, Jewish emancipation refers to the process beginning in the late 18th century by which Jews were granted civil and political rights: the right to vote, to hold office, to participate fully in public life. As recent scholarship has shown, the process wasn't once and done, but rather a long-term, multi-dimensional series of expansion and contractions in different times and places. But unlike some other emancipation narratives familiar to Americans, this one came with explicit, as well as implicit, conditions. During the French Revolution, one of the leading voices in the National Assembly famously put it this way, and I quote, "To the Jews as individuals, everything. To the Jews as a nation, nothing." That formulation captured the terms of the bargain. Jews were told, you may enter society, but only as individuals. You may enjoy equal rights, but only if you set aside claims of collective identity, peoplehood, or nationhood. What was being asked, in effect, was not simply integration, but erasure. The partial stripping away of those aspects of Jewish identity that did not fit comfortably within the emerging model of the modern nation-state. In other words, emancipation was not always offered as an unconditional right. It was often structured as a bargain, one in which inclusion was made contingent on a measure of self-erasure. And that brings us back to the Harvard debate question. Because the premise embedded in that question, that Jewish belonging may be conditioned, negotiated, or traded for assimilation, is not new. It is one of the oldest propositions in modern political and legal thought. What is striking is not simply that such a question could be posed, but that it has reemerged now, in this moment, and in this place. And this is not a normal moment. We are not meeting in the context of a theoretical discussion. We meet in the aftermath of October 7, and perhaps more significantly, in the aftermath of October 8, in the aftermath not only of Hamas atrocities, but also of subsequent campus upheavals here at Harvard, but also across the country, and of institutional responses that have, in too many cases, revealed not clarity and consistency, but double standards and dereliction. And the evidence of that strain is not anecdotal. According to recent survey data, 91% of Jewish Americans say they feel less safe as a Jewish person in the United States following a series of violent attacks just over the past year. On campus, 42% of Jewish students report experiencing anti-Semitism, and 1 in 4 report being excluded from a group or activity because they are Jewish. And perhaps most tellingly, 1/3 say they avoid displaying their identity out of fear, a quiet but profound form of collective self-erasure. What we are seeing, in other words, is not only the presence of hostility or a hostile environment. It is the adaptation of behavior to that hostility, a sign that conditions of participation have changed, that belonging in practice has once again become contingent. In that context, the resurgence of anti-Semitism we are witnessing is not simply a matter of increased hostility, it is testing something deeper. It is testing whether the civil rights framework can still do what it was designed to do, identify discrimination, apply standards consistently, and respond when those standards are violated. And like earlier challenges to emancipation, it is also an affront to the principles that made emancipation possible in the first place: reason, tolerance, equality, and the rule of law. And it is precisely in that context that the question has returned. The debate did not invent a new idea. It rediscovered an old one. The idea that Jewish belonging is conditional, that it may be granted, limited, or withdrawn depending on compliance with prevailing norms. The idea that emancipation is not simply a right but a bargain, that it may be exchanged for political and legal assimilation. And once we see it that way, the incident comes into sharper focus. What appeared to be a discrete controversy is in fact a window into a recurring structure, a pattern in which inclusion is offered, but only on terms that require the dilution or even the denial of Jewish identity, especially for those to whom Zionism is integral to their Jewish identity. That pattern has never fully disappeared. It has simply adapted, taking new forms, speaking new languages, embedding itself into new institutional contexts. It may no longer be framed explicitly as assimilation. Instead, it often appears as a demand that Jews distance themselves from core elements of their identity, whether religious, cultural, or connected to peoplehood, in order to participate fully in academic, cultural, or civic life. We can see this dynamic not only in theory, but in practice. For example, in litigation arising out of events at UCLA on the West Coast, a federal court recently considered allegations that a Jewish student was effectively denied access to portions of campus unless he disavowed his connection to Israel, an allegation serious enough to warrant preliminary injunctive relief. At other campuses, student organizations have adopted policies or practices that in effect condition participation on agreement with particular political positions, positions that many Jewish students understand as bound up with their identity as a people. These are not identical cases, but they reflect a common structure. Participation is not formally denied, it is conditioned on distancing oneself from certain forms of identity, conditioned on remaining silent about others. And that is the modern form of the old bargain. But what is striking about the present moment is that even this bargain is no longer holding in the way that it once did. We are seeing instances in which Jews who seek to participate as individuals, who do not foreground identity, who do not assert peoplehood, are nonetheless treated as outsiders. In other words, the promise that assimilation would secure acceptance has become uncertain. The language has changed. The expectations have shifted, but the underlying instability remains. But we should be candid about something else. In the aftermath of October 7 and the response that followed on many campuses and in many institutions, some Jews themselves have begun to ask a version of this question, quietly, sometimes reluctantly. They ask whether the promise of the American experiment has held, whether full inclusion is in fact secure. And that raises a deeper question. Not simply whether Jews will accept the terms of the bargain, but whether the bargain itself still even remains available. This is not a debating prompt. It is the central question of modern Jewish history. It is the question that has defined the terms of Jewish inclusion for more than 2 centuries, whether Jews may belong as Jews, as a people, or only as something different and perhaps less. And it is the question that each generation has been forced to answer anew, sometimes in law, sometimes in culture, sometimes in quiet expectations imposed by institutions that claim to welcome, but only on certain terms. To understand why this question keeps returning and why it feels so unsettled in our own time, we need to step back and see the larger pattern. For centuries, Jewish life in the West has followed a cycle, from emancipation to retrenchment, and when fortunate, to renewal. Periods of opening in which Jews are granted rights and welcomed into public life, followed by periods of contraction in which those gains are limited, contested, or quietly reversed, and then, sometimes, by periods of renewal, driven by law, by political change, sometimes by war, or by the determined effort of those unwilling to accept exclusion as inevitable and unwilling to accept the bargain. This pattern is not abstract. It has shaped Jewish life in the United States as well. And here is something that is not widely understood. In America, there has been not just one emancipation, there have been 2. The first emancipation began with the founding, although it did not emerge fully formed in a single instant. It was the culmination of a longer process, one that began well before the Constitution itself. By the time of the founding, Jews in the American colonies were not living under the conditions that had defined Jewish life in medieval Europe. They could own property, they could engage in commerce. In some colonies, they were permitted to worship openly and to participate in civic life. British reforms, including the Plantation Act of 1740, had already expanded pathways to naturalization. Colonial development, such as movement towards religious liberty in places like Virginia, further widened the space for participation, and yet the status remained incomplete. It was contingent. It depended on local law, local practice, and local tolerance. It varied from colony to colony. It could be limited or withdrawn. What the Constitution did was to change the foundation of that status by rejecting religious tests for federal office and by embedding a broader principle of religious liberty into the emerging constitutional order. It established something new, that participation in public life would not depend on religious identity, that Jews and others would enter the civic order not as a tolerated minority, but as citizens in principle. This was not yet a fully realized equality, but it was a decisive shift in terms of belonging, from contingency to constitutionality, from tolerance to right. And at the same time, as with earlier forms of emancipation, this transformation too came with a structural change. Jews were no longer recognized as a distinct legal community. They would participate as individuals, not as a corporate body. And the older forms of negotiated privilege and protected, however limited or imperfect, fell away. What they gained was equality in principle. What they relinquished was legal distinctiveness. That was the structure of the first emancipation. And like all such moments, it was both real and incomplete. Religious tests persisted at the state level well into the 19th century. Social and cultural barriers remained significant. The promise was real, but it was not yet secure. By the late 19th and early 20th century, that fragility gave way to retrenchment. Elite universities established quotas. Employers imposed informal barriers. Private institutions, clubs, resorts, law firms, medical practices, neighborhoods, social networks excluded Jews openly and systematically. This was not the repeal of emancipation. The formal framework of rights remained in place, but in practice, access narrowed, opportunity constrained, belonging became conditional again. The system had not collapsed, but it contracted. The second Jewish American emancipation emerged in response. In the mid-20th century, in the wake of the Allied victory in the Second World War, Cold War geopolitics, legal reform, cultural change, and the broader civil rights movement combined to dismantle many of the barriers that had defined the earlier period of retrenchment. Quotas weakened and then fell. Anti-discrimination norms took hold. Jews entered fully into universities, professions, and public life in ways that had previously been closed to them. For a time, it appeared that the cycle had been broken, that the terms of belonging had finally been settled. That emancipation did not feel provisional. It felt permanent. And in many respects, it was transformative. But as with the first emancipation, it operated within a particular framework. Jews were incorporated into a system that increasingly understood equality through the lens of race and ethnicity. And within that system, inclusion was often most seamless when Jews were understood primarily as a religious group, as part of a broader category of white Americans. That framework provided protection, but it also carried implicit limits. It did not fully account for the distinctiveness of the Jewish identity as a people, or for the ways in which hostility towards Jews could attach not only to religion or ethnicity, but to peoplehood itself. In that sense, the second emancipation expanded inclusion, but it did not entirely resolve the underlying structure. The form of bigotry changed, the categories of protection shifted, the question of full participation had not been resolved, even if the situation seemed to be secure. But as before, that sense of stability proved once again to be an illusion. In recent years, arguably since the onset of the Second Intifada, the Durban Anti-Racism Conference, and the birth of the boycott, divestment, and sanctions movement, but especially in the period following October 7, we have seen the emergence of a new retrenchment. It has taken the form of violence in places like Squirrel Hill, where Jews were targeted and murdered in a synagogue. It has taken the form of mass atrocity in the attacks of October 7, which reverberated far beyond Israel and reshaped the sense of vulnerability felt by Jewish communities worldwide, including right here. And it has taken the form, close to home, of hostility and exclusion in the very institutions that once symbolized the success of the second emancipation. What we are seeing is not simply a shift in tone or atmosphere. It is the reemergence across different domains of incidents that call into question the security of Jewish belonging, sometimes through violence, sometimes through exclusion, sometimes through the quiet but persistent sense that participation may once again be contingent, which is to say, the cycle has not ended, it has returned. And that brings us to the present moment. Not as an anomaly, but as an inflection point. Because the question now is not simply whether retrenchment is occurring, it is whether it will define the next phase or whether it will give way once again to renewal. In other words, can we turn the cycle again? If the Harvard debate question reflects the theory of conditional belonging, Berkeley, California, reflects its practice. At Berkeley Law, more than 20 student organizations adopted bylaws prohibiting the invitation of speakers who support Israel's right to exist, regardless of the topic under discussion. The effect was not simply to exclude particular viewpoints. This was an exclusion in practice of Jewish students and scholars from participation in ordinary academic life, unless they were willing to disavow or suppress a core element of Jewish identity. This is what the old bargain looks like in modern form. Not a formal revocation of rights, not an explicit declaration of exclusion, but a conditional environment in which participation is available on the condition that certain forms of identity are denied. This is not simply a matter of confusion. It reflects something deeper, a shift in the framework through which bigotry is understood and at some times excused. We see this most clearly when ideas that would have been unthinkable are now stated openly and defended as legitimate expression. At Columbia University, anti-Israel protesters explained that they are, quote, fighting for the total eradication of Western civilization, close quote. Here at Harvard, in the immediate aftermath of October 7, actually later in that same day, October 7 itself, more than 20 student organizations publicly attributed responsibility to the Hamas atrocities, not to the terrorists who carried them out, but to the victim country against which it was perpetrated. These are not identical statements, but they point in a similar direction, away from the values of the Western Enlightenment, reason, tolerance, and equality, values that underlie both the 250-year-old American constitutional order and also the very Jewish emancipation that Harvard students have just proposed to debate. And when this begins to erode, the consequences are not confined to rhetoric. They do not remain within the walls of any single campus. They spread. What begins as ambiguity about standards, about what counts as discrimination and what institutions must do and respond, does not stay abstract. It shapes behavior, it shapes expectations, and over time, it shapes outcomes. We have already seen these patterns extend beyond universities, into K-12 education, into professional associations and unions, into sectors like healthcare, and into other institutions that shape civic and professional life. At the same time, the effects on campus are becoming more pronounced. Jewish students report not only hostility but withdrawal, a shrinking willingness to participate fully in campus life, a hesitation to speak openly, and in some cases a decision to avoid certain institutions altogether. The consequence is not simply tension, it is absence, a gradual contraction of the space in which Jewish identity can be expressed without cost. And beyond institutional settings, we are seeing something even more direct. In recent months, there have been violent attacks targeting Jews in the United States and abroad, including the firebombing of a gathering in Boulder, Colorado, an arson attack on the residence of a Jewish governor carried out while he and his family slept inside, and in Sydney, Australia, the mass shooting at Bondi Beach. In Canada, Jewish schools have been shot at and synagogues targeted with arson and incendiary devices. In the United Kingdom, a synagogue in Manchester was attacked on Yom Kippur in a terrorist attack, and Jewish community vehicles set ablaze near a synagogue in London. These developments are not disconnected. They reflect a common underlying shift. When the line between discrimination and expression becomes unstable, when enforcement becomes uncertain, when standards are applied unevenly, the result is not neutrality. It is exposure to exclusion, culminating at times in violence. This brings us to the central question: how cycles of retrenchment are reversed. Law is not only vulnerable to retrenchment, it is the primary instrument through which retrenchment is overcome. But we should be candid about how that has happened in the past. Renewal has rarely come about through gradual adjustment alone. It has followed moments of profound disruption, moments that reorder political priorities, clarify moral stakes, and make legal change possible at a scale that would otherwise be unattainable. The first emancipation in the United States emerged from constitution making in the aftermath of the American Revolution, a moment in which the very structure of political authority was redefined. The second emancipation followed the Allied victory in the Second World War, a moment that exposed the consequences of racial and ideological extremism and helped catalyze the legal and cultural change that dismantled long-standing barriers, including quotas and discriminatory practices. In both cases, law did not operate in isolation. It operated in the wake of shock in a complex geopolitical, economic, social, and intellectual context. But law was what gave that moment lasting form. It translated upheaval into structure, into rights, into standards, into enforceable obligations. This is the role of law in every cycle of renewal. It may not create the moment, but it determines what the moment becomes. The question then is where we are now. We are clearly in a moment of retrenchment, but we are not, at least not yet, in the aftermath of the kind of systemic shock that has historically driven large-scale renewal. And that creates both risk and responsibility. The risk is that retrenchment deepens, that the erosion of standards becomes normalized before a corrective force emerges. But the responsibility is that the law must act earlier and more deliberately than it has in the past. And we are beginning to see the early signs of progress. Through litigation at Harvard, at Berkeley, and K-12 systems that forces institutions to confront patterns that they might otherwise deny. This very conference arises from the settlement of the Brandeis Center's litigation against Harvard University as an effort to turn that conflict into an educational tool for justice. Through federal engagement by the Department of Justice, the Department of Education, and importantly for us this morning, the Equal Employment Opportunity Commission that clarifies obligations under civil rights law. Through institutional settlements like ours that require not only acknowledgement but structural change. And through the adoption of clearer policies, including the International Holocaust Remembrance Alliance's working definition of anti-Semitism, which provides a framework for identifying conduct that might otherwise be dismissed or mischaracterized. These developments should not be overstated. They do not yet amount to a full renewal, but they are not insignificant either. They represent what may be the early stages of a response, an effort to assert clarity, consistency, and accountability before the kind of larger disruption that has historically driven change becomes necessary. If renewal is to occur without waiting for that disruption, law must do what it has always done at its best. It must name the harm clearly. It must define the standards consistently. And it must be enforced without hesitation. This is not a theoretical exercise. It has already begun to happen. Through litigation that compels institutions to confront patterns they might otherwise deny, through federal engagement that clarifies obligations under existing law, through settlements that require not only accountability, but institutional change. These are not yet a full renewal, but they may be early signs of one. The question is whether those efforts will remain fragmented or whether they can cohere into something larger. Because if they do, if they cohere, if we stand together, then this moment may not require the kind of shock that defined earlier transitions. It may instead become something rarer, a renewal driven not by catastrophe, but by clarity. If law is the instrument of renewal, then renewal does not occur through isolated cases or episodic interventions. It requires organization. It requires coordination. It requires strategy. The goal of civil rights legal action today must be legal renewal, not simply incremental, reactive, or transactional gains. Individual cases matter, but their significance lies not only in the outcomes they produce, but in whether they help reestablish stable standards, standards that can be applied clearly, consistently, and across institutions. That distinction matters because we have already seen what happens when legal responses fail to meet the moment. In 2024, the U.S. Department of Education's Office for Civil Rights entered into a series of resolution agreements addressing campus anti-Semitism. Those agreements were not without value. They required changes in policy, improvements in process, and commitments to training and oversight. But they were, in many respects, built on a pre-October 7 framework, one designed for a different set of conditions. They assumed a world in which the problem was episodic, manageable, and responsive to incremental adjustment. October 7 and the response that followed revealed something else, a broader and more systemic challenge, one that cannot be addressed through marginal change alone. And so the result in many cases was a gap between the scale of the problem and the scale of the response. Incremental reform at a moment that required something closer to structural clarification. In this moment, a legal movement must be organized across at least 3 mutually reinforcing domains that we address today: scholarship, litigation, and public policy. Each addresses a different point of failure. Each is necessary. None is sufficient on its own. First, scholarship. Renewal begins with clarity. Without a stable and widely understood account of what constitutes anti-Semitism, how it operates, how it manifests in contemporary settings, and where the line is drawn between protected expression and actionable discrimination, enforcement will remain inconsistent and contested. This is not merely academic. Civil rights law depends on shared definitions. It depends on the ability of administrators, regulators, and courts to recognize when conduct crosses lines. Where that understanding is unstable, the law becomes impossible to apply. And so the work of definition, through legal scholarship, institutional guidance, and frameworks such as the IRA working definition is fundamental. Second, litigation. If scholarship defines the harm, litigation compels recognition and demands accountability. Strategic litigation does more than resolve individual disputes. It clarifies obligations. It raises the cost of noncompliance. It exposes wrongdoing through civil discovery. It establishes precedents. It forces institutions to confront patterns they might otherwise deny or defer, and critically, it translates abstract principles into enforceable standards. Litigation drives change. With it, the law acquires force. And third, public policy. Even the clearest lines and the strongest precedents are insufficient if they are not embedded in institutional practice. Public policy is the mechanism through which legal standards are operationalized, through federal guidance, through regulatory enforcement, through institutional rules and procedures, and through conditions attached to public funding. It is what ensures that rights recognized in principle are realized in practice. Taken together, these 3 domains form a single system. Scholarship defines the problem and identifies the standard. Litigation enforces the standard. Public policy embeds the solution. When they operate in isolation, progress is partial and unstable. When they operate together, they can establish the clarity, consistency, and predictability on which civil rights law depends. Renewal will not be achieved by any one of these alone. To occur, it must have alignment of each of them. This is not a call for special treatment. It is not a departure from the civil rights tradition. It is a demand that the existing framework operate as it was designed to operate, clearly, consistently, and without regard to shifting ideological commitments. Because what is at issue is not simply whether particular incidents are addressed. It is whether the cycle we have traced of emancipation, retrenchment, and renewal can be turned again. It is whether the phase of entrenchment will harden into a new baseline, or whether it will be met with a response strong enough to reverse it. It is whether the legal framework that underwrote the second emancipation can be restored, not only in principle but in practice, or whether the protections that it offered will become increasingly contingent as the situation continues to erode. And more broadly, it is whether these principles that make the framework possible will remain stable enough to sustain equal protection in a period of growing challenge. Because if those principles cannot be maintained, if clarity gives way to ambiguity, if consistency gives way to selectivity, then the question is no longer how one group will fare within the system, it is whether the system itself can continue to function. If the pattern that we have traced is correct, if periods of retrenchment are followed sometimes, but at critical moments by renewal, then the question before us is not simply how to respond to each incident or challenge. It is whether we can be at the threshold of such a moment now, not simply a continuation of the second emancipation, but the beginning of a third. A third emancipation would mean something both familiar and new. Familiar in that it would reaffirm a basic principle of American life, that citizenship is not conditional and that rights do not depend on the suppression of identity. But new in that it would not require that principle to be applied. It would require that principle to be applied with clarity and consistency that has not always been present. At its core, the third emancipation would mean this: full civic inclusion without erasure, secured by law, and sustained by institutions. That formulation requires a departure from the terms on which emancipation has historically been defined. At the moment of the first emancipation, as we have seen, those terms were stated plainly. To the Jews as individuals, everything. To the Jews as a nation, nothing. That was the Enlightenment bargain. It offered protection against religious bigotry, freedom of conscience, equality before the law, but on a condition: that Jews would enter public life as individuals, not as a distinct people, and that organized expressions of Jewish particularity would recede from view. The second emancipation altered those terms, but it did not abandon their structure. In the mid-20th century, as legal protections against racial discrimination expanded, Jews were increasingly incorporated into the framework of American equality. But here, too, inclusion carried an implicit expectation that Jews would be understood primarily within existing categories, and that aspects of Jewish distinctiveness, especially those that did not fit comfortably within those categories, would be de-emphasized. The third emancipation must proceed on different terms. It must confront a newer form of hostility, one that often presents itself through opposition to Jewish peoplehood, and in particular to its contemporary expression in Zionism. And it must do so without recreating the old conditions, without requiring Jews to become less visible, less particular, or less connected to their identity as a people in order to participate fully in civic life. The premise must be clear: that Jewish identity, in its religious, cultural, and peoplehood dimensions, including the Zionist commitment that is central to the identity of the Jewish people, is fully consistent with equal citizenship in our constitutional republic now and forever. The first emancipation asked Jews to privatize their faith. The second, to conform to prevailing ethnic and racial categories. The third must ensure that Jews are not required to disavow peoplehood in order to belong. This is not an abstract aspiration. It is a legal project, and it depends on the same elements that have driven renewal in prior periods: clear definitions, consistent application, enforcement mechanisms, including effective enforcement of Title VI and Title VII. Because what is at stake is not simply protection from harm. It is not only whether particular incidents are addressed or claims vindicated. It is the terms of belonging in America, whether that participation in public life is unconditional or contingent. And that is why this moment matters. Not because it is unprecedented, but because it presents a familiar pattern and a choice about how that pattern will unfold. Whether retrenchment will deepen, or whether through law, through institutions, and through sustained effort, it will give way once again to renewal, to something that, in retrospect, we may come to recognize as a third emancipation. If the question posed here at Harvard was whether Jewish emancipation should be conditional, then the purpose of this conference is to answer that question, legally, politically, and decisively. And the structure of this day reflects that purpose. We begin with a discussion of what it means to speak of a Jewish civil rights movement in our first panel, not as an abstraction, but as an organized legal and institutional effort. This is the work of developing strategy, institutions, and leadership around the task of renewal. That conversation is followed by a dialogue on enforcement, how civil rights law is applied in practice, and what it requires of institutions charged with carrying it out. In that conversation, I will be joined by Andrea Lucas, chair of the Equal Employment Opportunity Commission, whose work reflects a central truth of civil rights law: the rights not secured by that rights are not secured by declaration alone. They are secured by vigorous, consistent enforcement, because a right that is not enforced is not, in fact, a right at all. In the afternoon, we will turn to definition, and we will conclude with a discussion of legal scholarship, the work of embedding those questions within the academy itself so that the next generation of lawyers, scholars, and policymakers approaches them with clarity rather than confusion. Taken together, these discussions reflect the domains necessary for renewal, scholarship, litigation, and public policy. And that brings us back to where we began. The question that surfaced here at Harvard, whether Jewish belonging must be conditioned on assimilation, is not new. It is as old as emancipation itself. The task before us is not to debate it again. It is to resolve it clearly, lawfully, and finally, so that Jewish American rights and the rights of all Americans are not contingent, not negotiable, and not subject to exception, exclusion, or erasure, but secured as they must be as a matter of right. Thank you.